Enga mana, enga reo rangatira, onge hoitha, ten na koutou katoa. My name is Bryony James. I'm the Provost here at Te Herangawaka, Victoria University of Wellington. It's my very great pleasure to welcome you all to this evening's event. Welcome to our distinguished guests, welcome Chief Justice, and welcome to representatives of the Cooke family, Philip and Francis especially. The Robin Cooke Lecture is the highlight of this faculty's events calendar and commemorates the life of Lord Cooke of Thorndon. Robin Cooke was an alumnus of this university and is widely considered New Zealand's most eminent jurist. He is the only New Zealand judge to have sat in the House of Lords in the UK. I'd like to take this opportunity to acknowledge Francis Cooke, who has recently been appointed to the Supreme Court, and to extend my warmest thanks to the Cooke family, Philip and Francis in particular, who generously support this lecture and are very much part of this faculty's wider whānau. Since this is the final major event of this faculty's calendar, apart from graduation in a few weeks, which of course all the staff will be at, it's also nice to take this opportunity to celebrate some recent achievements of our staff in the university's Kitipai Staff Excellence Awards, where Professor Nicole Moram was awarded the Research Excellence Award. Professor Joanna Mossop was awarded the Excellence in Research Mobilisation Award, and Kelly Mitchell received the Mai Iti Iho Kitipai Special Commendation for her work integrating tikanga Māori into first-year law teaching. Congratulations to each of them. The Cooke Lecture is always delivered by a world-leading legal expert, and this year is no exception. So it's my very great pleasure to welcome our guest speaker this evening, Dr Síofra O'Leary. Síofra is a former judge and president of the European Court of Human Rights. She's the first woman elected to the president of the position. Prior to joining the European Court of Human Rights, she worked for almost 2 decades in the Court of Justice of the European Union at both judicial and administrative capacities. She is currently a Hauser Remarque Global Fellow at New York University. She's a full adjunct professor at the University College Dublin and a visiting professor at both the College of Europe in Bruges and Instituto de Empresa in Madrid. And if that list leaves you feeling a little exhausted, I'm not surprised. Just last year, University College Dublin conferred on her the Ulysses Medal in recognition of her legal work and European service. I know I speak for all of us in saying how honoured we are to have her speak tonight. In this evening's lecture, Síofra will discuss the response of Europe's Regional Human Rights Court and other regional and international tribunals to climate change litigation. And she will explore the nature of and the limits to the judicial role in the field of climate change. This event is a long-standing tradition of this faculty, and I'm delighted to once again be here to enjoy it. Please join me in welcoming Dr Síofra O'Leary.
Many thanks, Provost. Chief Justice, distinguished judges, distinguished members of the law faculty, ladies and gentlemen. It gives me enormous pleasure to speak to you this evening on a subject which, like it or not, concerns all of us. I didn't ask for the tsunami warning, but perhaps that's appropriate. It's also a tremendous privilege to have been asked to deliver this lecture in honour of Judge Cooke, with members of his family in attendance. Given the slip of the tongue earlier in the week when visiting the courts, I should stress that I mean to honour Judge Robert Cooke and not Judge Francis, although I warmly congratulate him, with many others here, on his recent appointment to the Supreme Court. If you had asked me when I was a young law student in Dublin in the late 1980s, would I one day cross the globe to speak to the challenges facing courts dealing with climate change litigation, I would have thought the idea completely preposterous. I was reared on an island whose native language provides almost 100 words to describe the different types of rain which renders it so green. Climate change was not on our horizon. But aside from the carbon footprint, equally important to the preposterousness in my mind would be the Irish psyche. My generation of young professionals, which includes Andrew Butler, KC, a good friend from UCD, was probably the first to experience immigration as professional choice rather than economic imposition. However, the weight of history lies heavy upon many of us. Like Lord Cooke, I was a fellow at Cambridge University. I can't presume to know what it was like for the late judge to navigate the English legal world as a young student in the 1950s or later as Lord Cooke of Thorndon. He came from a legal family, whereas I had to bridge the confidence gap which being a legal pioneer inflicted on many in my generation, if I may add, particularly women. But my guess is that our experiences may at times have borne some similarities, despite obvious differences pertaining to our generations, our gender, and our provenance. Both of us come from common law countries where judges became determined with time to emancipate the law from English influence. And I say that citing your former Chief Justice, who I know is here, Chief Justice Elias. Both of us came from countries whose justice systems slowly became more comfortable in themselves in the last 50 years or so. The one area, I think I have to call it out, where division would probably have been assured between myself and the late judge is rugby. Rugby is a sport which I have to watch exclusively in the comfort and privacy of my own home, due to what I will politely call the warmth of my engagement with the 4 proud provinces of Ireland. But with our defeat at Soldier Field uppermost in your minds and my own, let me turn promptly to the keynote speech. As many of you know, in April 2024, the European Court of Human Rights handed down 3 judgments in climate change cases. While New Zealand is not, of course, bound by the 75-year-old convention, it has ratified other international human rights instruments and is party to the international climate change treaties, which served as part of the backdrop to the Strasbourg Court's rulings. In addition, if New Zealand was at one time, in the words of Lord Cooke's eulogist, Chief Justice Elias, precious about the citation of foreign sources, Judge Cooke did much to change that outlook. For those not familiar with the convention system, I should explain briefly as an aside that it allows applicants, mainly individuals and groups of individuals, to introduce legal complaints against the 46 high contracting parties who signed up to the convention in relation to acts or omissions which allegedly interfere with their human rights and which fall within the jurisdiction of those states. Applicants must have exhausted domestic remedies before national courts for their cases to be admissible, and they must demonstrate what's called victim status. But the latter is a notion, as we'll see, which the court has interpreted flexibly to capture a wide variety of different scenarios and to ensure the practical and effective implementation of convention rights. In my keynote, as you see, I'd like to explore the role of courts and the limits to their role when dealing with climate change litigation. What are the similarities and the differences which we find in the reasoning of all 4 international jurisdictions who have decided climate change cases in the last year and a half? The Strasbourg Court, the International Tribunal on the Law of the Sea, the Inter-American Court of Human Rights, and of course, the International Court of Justice. Before looking at the convention cases, I'll refer to the court often as the Strasbourg Court because that's where it sits. I'll briefly outline some of the climate change rulings handed down by courts in European Union member states. After all, it was national judges in European states and not the European Court of Human Rights who first relied on the European Convention as part of their national legal response in climate change cases. I have to apologise, being in New Zealand, for my focus on European courts, but these are naturally the courts with which I'm most familiar. And later on, I will turn to some non-European courts, including the impressive engagement of some parties and courts in New Zealand. Because in the final part, I'd like to reflect on the reaction of courts in common law jurisdictions and beyond to developments in European and international law as a result of climate change litigation. In this regard, I'm going to raise a question which I will prudently leave you to answer yourselves. At a time when the legitimacy and authority of international and even national courts is often challenged around the globe, do clever judges and clever legal commentators, whose job it is to inform and not just to opine, not act as their own worst enemies, when they fail to properly digest and display what courts actually say in their judgments, or when they simply oppose as a matter of course judicial engagement with climate change, looking backwards to where the law was, rather than looking forwards to where the law might have to go. It would be impossible to explore climate change litigation without first providing a contextual snapshot. The first point of relevance is scientific. According to abundant scientific evidence, anthropogenic global warming is affecting every climate system component and is disrupting the integrity of all ecosystems worldwide. The Intergovernmental Panel on Climate Change, the IPCC, has established that to limit warming to 1.5 degrees Celsius above pre-industrial levels with no or limited overshoot, global greenhouse gas emissions need to peak no later than 2025. This is climate science, unloved by many, disputed by some, including at the recent UN General Assembly, but nevertheless tried and tested scientific fact. The second contextual element is political. On the 20th of January, the US withdrew for the second time via an executive order from the Paris Agreement. It thereby rejoined the unlikely company of Iran, Libya, and Yemen, who have never ratified that agreement. In February 2025, the US also withdrew from the IPCC, whose work is reflected in the marriage of law and science in the International Court's rulings, which we'll examine this evening. The EU, previously a climate change legislative pioneer, is regarded nowadays by many as backtracking on its previous role. And just last week, COP30 stumbled to an inconclusive end. I'll leave it to experts to say more in relation to COP30. In short, courts, national and international, are faced with climate change litigation at a time when the relevant science is ever clearer, but the political context in which they work is ever more fraught. And as judges and lawyers, you know that when the gap grows between what legal norms provide and what politics is willing to permit, increased litigation is often the result. It's important to stress that climate change litigation can involve a broad range of parties, individuals, NGOs, governments, and corporations. It can involve a broad range of legal principles, tort, constitutional, administrative law, environmental law, the law on corporations, securities, etc. And it can also involve a wide range of acts, policies, and practices. A rapid change in climate change litigation, and particularly what is referred to as the human rights turn, is of relatively recent vintage. Between 2019 and 2024, several apex courts in Europe were confronted with novel climate change suits. I'm thinking of the Netherlands, Germany, France, the United Kingdom, Belgium, Spain, and Ireland. The ones I'll focus on are systemic mitigation or framework climate change cases, in which applicants challenge the lack of state measures to mitigate the effects of climate change or the inadequacy of those measures. What are the key takeaways from these different rulings and how those cases were litigated? Firstly, noteworthy in cases in which complaints were found to be at least admissible and climate change questions justiciable was acceptance of the climate science presented as evidence of causation and standing by applicants, as well as explicit recognition of a climate emergency. The reports of the IPCC emerged as central and authoritative in such cases. A second takeaway relates to the centrality in applicant submissions and in some of the final decisions in their favour of states' domestic and international commitments, following agreements like the United Nations Framework Convention on Climate Change, the UNFCCC, and the Paris Agreement. A recurring pattern in these cases was for applicants to ask the courts to take the goals of the international climate regime and rely on the state's international and national commitments in their regard to assess the climate action or the climate inaction of their governments. The extent to which national courts were willing to engage in what's called systemic integration or interpretation of this nature greatly influenced the success or failure of the national claims. Thirdly, the European Convention on Human Rights took on a lead or supportive role in some but not all of this litigation, most notably in the groundbreaking Dutch decision, which some of you will have heard of, called Urgenda. In ordering the Dutch state to adopt more stringent greenhouse gas emission reduction measures in line with its international legal commitments, the Dutch court didn't directly find a violation of the applicant's human rights. However, it used the convention as an interpretative tool in analysing the question whether the Dutch government had been in breach of its duty of care under Dutch law. In other cases, although the convention was cited and relied on by litigants, I'm thinking of the Irish and French courts, those courts were either silent or highly sceptical about the role that the convention could play. The fourth takeaway from these national decisions in Europe is that in several of these cases, questions arose regarding the protection of present and future generations from future climate change risks. The standout case in this regard is the decision of the German Federal Constitutional Court. It interpreted a specific provision of the Basic Law, the German Constitution, as encompassing the necessity to treat the natural foundations of life with care and to leave them in such condition that future generations are not forced to engage in radical abstinence. The Dutch, the German and Belgian decisions, which preceded the Strasbourg rulings, were groundbreaking. Legislative provisions presently in force were identified as the source of impermissible state interference with the enjoyment of fundamental rights, which interference was also located in the future. In the words of the German court, fundamental rights are intemporal guarantees of freedom. A fifth takeaway relates to standing or causation, with the approach to standing varying from national openness to cases brought by individual applicants, that was the case in Germany, to systems which naturally accommodated complaints by climate associations. I'm thinking of the Netherlands, Belgium, and France. As regards causation, again, climate science was front and centre. And finally, the separation of powers was discussed directly or indirectly in all of these cases, with recognition in all that the legislature and the executive, given their direct and democratic legitimation, must enjoy considerable leeway in deciding how to tackle climate change. However, there was also considerable disagreement amongst national courts regarding the role of the judiciary in this complex field and the limits to that role. For example, the Belgian Court of Appeal held that courts do not infringe the separation of powers in climate change cases when exercising judicial review, provided that judges do not take the place of the authorities in choosing the means to remedy any breaches found. In contrast, the High Court of England and Wales argued that the claimants before it were asking the court to answer questions with which it was not well equipped to deal and to venture beyond its sphere of competence in breach of the separation of powers. Many of the courts with a more cautious stance were the same courts which did not showcase the climate science, the work of the IPCC, or the international legal climate regime. These European cases point to the fact that climate change cases thus far have historically been vertical cases, cases filed against the state. But this trend is now changing, and it will likely change further, following the advisory opinion of the International Court of Justice, given that it requires states to regulate corporate behaviour to fulfil the state's own climate change obligations. As we see from this brief introduction, again, like it or not, by the third decade of the 21st century, climate change litigation has become a disruptive reality for national courts and established constitutional orders, challenging existing mechanisms of and approaches to judicial review. Turning to the three cases which were lodged in Strasbourg, the essence of the three complaints which were decided in 2024 was that state authorities had failed to respond adequately to combat the effects of climate change. The applicants were senior Swiss citizens, otherwise known in the press as the Swiss grannies, an environmental association, a former French mayor, and a group of Portuguese children. and they framed their complaints with reference to Articles 2, 8 and 6 of the Convention, which relate to the right to life, the right to privacy, and the right of access to court. I am, of course, simplifying the three cases. It's important also to note that the Portuguese children brought their case not just against their own state, Portugal, but also against 32 other European states. And as many of you know, the court found in the Swiss case, a case called Klima, that Article 6 had been violated because of an absence of access to court for the Swiss Association. As regards Article 8, which is the right to privacy, it held that the Swiss authorities had failed to act in good time and in an appropriate and consistent manner regarding the devising, development and implementation of the relevant legislative and administrative framework tackling climate change. The Portuguese children failed due to an absence of exhaustion of domestic remedies. In other words, they hadn't gone before the Portuguese courts to argue their case, and because as regards the 32 other states, the court could not accept that extraterritorial jurisdiction applied under the Convention. And the French former mayor's case failed because of a lack of victim status. As the judges of the court discovered belatedly during the hearing, he no longer resided in the region which was under threat. It's far too early, in my opinion, despite what some academic commentators have claimed, to judge the long-term impact of the Strasbourg Court's climate change trilogy. Judicial milestones, as I think the judges here present know, are ones which feed the case law for decades to come, with ups and often some downs on the way. However, in the light of the Strasbourg rulings and the 3 subsequent advisory opinions handed down this year, I think it is fair to say that the goalposts regarding how courts and national authorities have to approach human rights, climate change litigation, and questions of state responsibility more generally have shifted somewhat since Strasbourg first spoke. I limit myself to 6 key takeaways from the 3 rulings, and most of these takeaways mirror the ones that I've just provided, which you can deduce from national courts' decisions. Where possible, I'll also cross-refer to the relevant parts of the ITLOS, Inter-American Court, and ICJ advisory opinions to give you a sense of how consistent certain lines of judicial reasoning across the 4 distinct jurisdictions have been. A few further introductory words regarding the Convention itself I think might be useful. Firstly, the Strasbourg Court interprets the European Convention as a living instrument. In other words, it interprets the Convention not as it was when it was adopted 75 years ago, but in the light of present-day conditions and the ideas prevailing in democratic societies today. In addition, 45 years ago, in a case called Airy against Ireland, the Strasbourg Court relied on the living instrument document, and it recognised that fulfilment of a duty under the Convention can, on occasion, necessitate some positive action on the part of the state, which cannot simply remain passive. Secondly, no article of the European Convention is specifically designed to provide general protection of the environment, and there's no convention right to a healthy environment. Only such environmental harm which adversely affects one of the rights safeguarded by the Convention can raise an issue before the court. That said, well, these 3 cases were the first climate change cases that the court had been confronted with. It had at its disposal extensive case law, particularly under Articles 2, the right to life, and Article 8 on privacy, in the environmental field. For well on 4 decades, the court had repeatedly held that the responsibility of state authorities in that field should in practice result in their intervention at the appropriate time in order to ensure that the statutory provisions enacted with the purpose of protecting the environment are effective. Keep words such as due diligence in mind this evening, because you'll hear them during the course of my speech. So what does the Strasbourg trilogy tell us about the role of courts in climate change litigation and the limits to that role? The first important takeaway, believe it or not, is the importance of democracy and the separation of powers. According to a former member of the United Kingdom Supreme Court, who you will probably know well, Lord Sumption, I think it's fair to say he's not a Strasbourg fan, speaking just after the decisions were handed down in a newspaper article, he said, and I quote, "The Swiss climate ruling is the boldest intrusion to date into the domain of democratic politics and a direct challenge to the right of democratic electorates to have their say on one of the major issues of our time. But is that so? I'd like to unpick the Strasbourg Court's decisions with you and look at actually what the court said and what the court did. In the Klima case, the court engaged in unusually extensive preliminary observations, pointing out that responding to the adverse effects of climate change primarily requires legislative action, which necessarily depends on democratic decision-making. The court stressed that if national or European law impose on states a positive obligation to act in mitigation of the effects of climate change, this obligation falls primarily on the shoulders of the political branches of government. The central position of national and EU democratic decision-makers tempers the nature and extent of any judicial involvement. But the court stressed that it doesn't exclude the possibility of judicial involvement. Far from ignoring the centrality of democratic decision-makers, the separation of powers, and the limits to judicial intervention in a field as complex and polycentric as climate change, the Strasbourg Court spoke directly and deliberately to those issues throughout the rulings. Takeaway 2 is the centrality again of climate science. One paragraph alone of the Swiss judgment demonstrates, in my opinion, the general but modest importance of these rulings, whatever the legal future brings. In paragraph 436 of Klima, the court made clear that it proceeded on the basis that, and I quote, there are sufficiently reliable indications that anthropogenic climate change exists and that it poses a serious current and future threat to the enjoyment of human rights guaranteed under the Convention. The rulings thus showcase the existing science and, as other national courts in Europe had done previously, confer on it the imprimatur of judicially recognised fact. While most commentators point out that in climate change litigation nowadays, the scientific evidence is rarely in dispute, the fact remains that the science is hotly contested in some political spheres. Look no further than the very different arguments of some intervening states before the International Court of Justice, or how Bill Gates' recent pronouncements on climate change prior to COP30 were construed. Turning to the late Judge Cooke for support, he considered that the work of courts reflects the human need to confront issues that matter in a formal process before a disinterested tribunal. In the current climate, the pun is intended, of contestation and polarization, the provision of public affirmation of tested scientific consensus should not be disparaged, but should rather be protected. And surveying national, European and international court rulings in relation to climate change, the work of the IPCC is central to all of them. In my view, at a time when we lament the demise of the post-war international rules-based order and a loss of public faith or interest in epistemic facts, we should rejoice that, as evidenced not just by work on climate change, but also the response to COVID and multiple other health and public order questions, global scientific enlightenment remains alive and kicking. The third takeaway is the relevance of the international climate legal regime. The European Court emphasised, again very deliberately, that it can deal with human rights issues arising as a result of climate change only within the limits of the exercise of its competence under Article 19 of the Convention. Its jurisdiction doesn't and cannot extend to supervision of compliance with other international treaties or obligations. This didn't render, however, international treaties such as the Paris Agreement or the UN FCCC irrelevant. The court regarded such instruments as representing both international consensus in the climate change field and reflecting the requirements and commitments which Convention states had undertaken to respect. This general approach to interpretation, which is in line with the principle of systemic integration in the Vienna Convention, and was also reflected very clearly in the advisory opinions of ITLOS, the Inter-American Court, and the ICJ, was also offset in the judgments by extensive paragraphs on the Convention's role and the limits thereto, which are bound, you will find them in the judgment and in the two inadmissibility decisions. The living instrument document, the principle of evaluative interpretation, and the court's examination of international materials made it impossible to ignore the pressing scientific evidence and the growing international consensus regarding the critical effects of climate change on the enjoyment of human rights. However, to recognise that human rights climate mitigation cases and international advisory opinions have provided procedural and substantive mechanisms for translating international climate treaty targets into legally binding commitments is not to suggest that instruments like the Convention serve to judicially enforce instruments like the Paris Agreement. The interplay is both simpler and more complex than that. The international treaties form part of the common ground which the European Court of Human Rights will look at when assessing state compliance with their Convention obligations. Climate protection is provided by ricochet via the human rights obligations flowing from the Convention itself. The fourth takeaway, and again you'll see reflection of what was decided by other national courts in Europe, is the relevance of future generations, many of whom are here present this evening. One of the most important developments in the rulings is the court's acknowledgement in the climate change context of the relevance of intergenerational burden sharing. This recognition is not unique to the European Court, as one can see from the German judgment that I cited previously. In the Swiss case, the court expressly stated that future generations are likely to bear an increasingly severe burden of the consequences of present failures and omissions to combat climate change. And crucially, it also recognised that they are at present at a representational disadvantage in the relevant current decision-making processes. However, looking to the limits on the role of courts, it's important to stress that intergenerational burden sharing form part of the court's reasoning in relation to its approach to standing, which I'll look at in a second, and to the nature and scope of the positive obligations it identified under the Convention. Intergenerational burden sharing was not a self-standing reason for the creation of new rights. The fifth takeaway, and probably for the lawyers and practitioners here present is the most important one, relates to causation and standing requirements. In the Swiss case, the court noted that while an important source of inspiration and guidance, its existing environmental case law was not directly transposable to climate change cases because there are some critical differences between climate change and classic environmental cases. The main difference is the absence of a linear and clearly ascertainable nexus between a specific source of harm, the nature of the harmful activity, and those individuals affected by that harm. In climate change cases, the relevant nexus is much more complex, and the effects of any harm are much more diffuse. And it is, of course, at this point that questions relating to causation and standing arise. One of the great challenges facing litigants in the early phases of climate change litigation was the establishment of causation. But the court in the Swiss case addressed the 4 dimensions of causation in detail, all of which are relevant under the Convention. Were this a student lecture, I would detail all 4 and in great detail, but I think you will thank me if I don't do that this evening. As regards state responsibility, the court rejected what's called the drop in the ocean argument, the idea put forward by some states that there is an insufficient capacity of individual states to affect what is essentially a global phenomenon. According to the court, the relevant Convention test in relation to positive obligations doesn't require it to be shown that but for the action or omissions of the respondent state, the harm alleged would not have occurred. What is important and sufficient to engage the responsibility of the state under the Convention is that reasonable measures which the domestic authorities failed to take could have had a real prospect of altering the outcome or mitigating the harm. Once again, in this respect, the Swiss judgment mirrors both the preceding work of national courts and the subsequent advisory opinions. Of course, another recurring obstacle for applicants in contentious proceedings is whether or not they comply with national, European, or international standing requirements. In order to seek Convention protection from the Strasbourg Court, An individual needs to show that he or she is affected by the actions or omissions of which they complain. The European Convention doesn't recognise what's called an actio popularis. There's no possibility to institute convention proceedings to ensure protection of a general cause, for example, the environment, or to seek abstract review of domestic law and practice. The actio popularis restriction doesn't, however, exclude actions of a collective nature, in which a group of individuals affected may seek protection of the interests which unite them. Victim status within the Convention, and this is an important difference perhaps with national courts, covers direct, indirect, and potential victims, and it is amenable to evolutive interpretation, and it has never been applied in a rigid, mechanical way. One of the main obstacles for the individual applicants in the Swiss case related to the question of victim status. As the court explained, if the circle of victims within the overall population of persons under the jurisdiction of the state, actually or potentially adversely affected, is drawn in a wide-ranging and generous manner, this would risk disrupting national constitutional principles and the separation of powers by opening broad access to the judicial branch as a means of promoting changes in general policies regarding climate change. If, on the other hand, this circle is drawn too tightly and restrictively, there is a risk that even obvious deficiencies or dysfunctions in government action or democratic processes could lead to convention rights of individuals being affected without them having any judicial recourse. In relation to individuals, the court established a particularly high threshold in the Swiss case tailored to the climate change context. It was clearly aware of both floodgates arguments and mindful of the actio popularis restriction. And the individual applicants in the Swiss case and in the French case were found not to have fulfilled the very high standards established by the court. However, as regards standing, the Swiss case presented the court with an additional question. Could the applicant association enjoy victim status or standing to represent the interest of others? The Swiss courts hadn't examined this issue. It only focused on the individual applicants, and it rejected their complaints as actio popularis. And it's important to stress that in previous environmental cases, the court had repeatedly emphasized the following, and I quote, "In modern-day societies, when citizens are confronted with particularly complex decisions, recourse to collective bodies such as associations is one of the accessible means, sometimes the only means, available to them whereby they can defend their particular interests effectively." One of the main innovations in the Swiss judgment is to grant standing, provided certain conditions are met, to collective entities to defend the rights and interests of affected members or individuals. I should stress that associations cannot rely on health considerations or nuisances and problems associated with climate change, which can only be encountered by natural persons. The standing conditions for associations, however, didn't include the requirement that the individuals who had also lodged their complaints would themselves qualify individually under the victim status test, which is strict, as I just outlined. This was perhaps the thorniest issue in the Swiss case, the need to square the prohibition of an actio popularis with the grant of standing to an association, but not to 4 individual members of that association. However, cases stemming from a systemic problem, such as climate change, which poses a universal, if differential, risk to all human beings, are not necessarily actio popularis, as long as they concern affected persons, what one author has characterized as second-degree victim status. In cases since Klima, the court has both accepted the standing of an environmental association in a Norwegian case, and it has restricted the recognition of standing for associations as being justified by the specific considerations of relevance in climate change cases. For the critics, and there are a few, who don't want to see climate change mitigation cases in whatever form before courts, the innovation on standing has been one of their principal lines of attack. However, the Swiss, French, and Portuguese cases demonstrate well the causality and temporality obstacles which human rights climate change mitigation cases come up against. We are all affected, albeit differently, and the effects of the interferences and omissions being challenged will mainly manifest themselves in the future. Furthermore, the dominant paradigm in human rights cases is a liability model of responsibility, which is backward-looking, and it focuses on determining responsibility for individualized rights violations. In Klima, reflecting the approach of several national courts, the Court of Human Rights was forward-looking, seeking to respect the central purpose, object, and mechanics of the Convention, while also articulating a limited but new approach to standing in order to respond to the precise difficulties associated with the causality and temporality of climate change and the complexity of climate change litigation. As regards standing, I contend that the Strasbourg Court engaged in evolution, yes, but revolution, no, which seems an appropriate moment for me to reference, delicately I promise, your own court's decisions in Smith against Frontera and Smith against Attorney General. I hear you all take a sharp intake of breath. And I promise you that I've walked on more difficult eggshells than these. I realise that one of the cases is now pending before the High Court, and that a decision on leave to appeal is awaited in the other case. And I'll limit myself, like a prudent judge, to a description of what your courts have done so far, drawing links from the perspective of a European judge between continents and between cases. When choosing this topic, I should stress that I had no idea that these cases were pending, and I will evidently not trespass into another court's deliberation processes. As you know, the Supreme Court disagreed with the Court of Appeal in Smith against Frontera in relation to the special damage rule, standing and causation. You can tell me afterwards what I got wrong. It found that, and I quote, "While the effects of human-caused climate change are ubiquitous and grave for humanity, their precise impact is distributed and different." Your court was unwilling to accept, without a trial, evidence and policy analysis, that the range and diffuse and disparate causes of climate change exceed the capacity of the common law. It held instead, and I quote, "The principles of public nuisance ought not to stand still in the face of massive environmental challenges attributable to human economic activity." I understand that your court has experienced backlash, probably, I guess, from some quarters in this regard, so I will phrase my comment as an outsider prudently. The reasoning of your court struck me as careful, and it struck me also as an example of evolution, not revolution, something which the common law has accommodated for centuries and which the European Convention has accommodated for 75 years. At Court of Appeal level, in the parallel case, Smith against the Attorney General, the applicant's human rights claim was rejected as clearly so untenable that it was bound to fail. That court, reproducing extensively extracts from the judgment in Klima, which I thank them for, aligned itself with the High Court of England and Wales in a case called Plan B Earth, and considered that the constitutional separation of powers precluded an examination of the adequacy of the national regulatory framework. Suffice it to say, as I said again, since the case is now the subject of, I think, a leave to appeal decision and has nothing to do with me, that the Supreme Court will have at its disposal not just the Strasbourg judgment, but subsequent applications of its general principles by the European Court of Human Rights and at national level, as well as the advisory opinion of the ICJ. In addition, I think it is worth emphasising, and this is just a point of fact and law, that the Court of Appeal of England and Wales, which was not mentioned in the Court of Appeal judgment, had held that fatal to the request for leave to appeal in Plan B Earth was the absence of Strasbourg authority to support the appellant's human rights claim. That, of course, is no longer the case because Strasbourg has spoken. Taken away number 6 concerns the relationship between human rights and climate change, turning first to access to justice. At the heart of these 3 rulings is the importance of access to independent and impartial national courts and effective national remedies. The court stated in Klima in relation to the Article 6 access to court complaint that where future harms are not merely speculative, but real and highly probable or virtually certain, In the absence of adequate corrective action, the fact that the harm is not strictly imminent should not, on its own, lead to the conclusion that the outcome of the proceedings would not be decisive for its alleviation or reduction. In the Swiss case, the court found a violation of Article 6, since there was no avenue under Swiss law which the climate complaints of the applicant association could be brought before a court. In fact, the Swiss courts considered that there was still some time to prevent global warming from reaching the critical limit, and it didn't engage seriously, indeed it didn't engage at all with the action brought by the applicant association. As regards the right to respect for private life, the content and scope of states' positive obligations under the European Convention, of course, only, in the context of climate change, have been defined in the Swiss judgment, in which the court preferred to look at the right to respect for private life, not the right to life. It held that Article 8 contains a positive obligation to protect individuals from the adverse effects of climate change on their life, health, well-being and quality of life. Secondly, the state's primary duty is to adopt and to effectively apply in practice regulations and measures capable of mitigating the existing and potentially irreversible future effects of climate change. This was groundbreaking because this was the first climate change case dealt with by the Convention Court, but it was not unprecedented. The Court's Article 8 environmental case law had required proactive risk management and due diligence by states for many years. And contrary to the dissenting judge, who's a good friend and who I respect very much, it's difficult to see what new convention right was identified. Instead, old rights were tailored and applied to a new context. The positive obligations identified also crucially have to be read with reference to the margin of appreciation from which all states benefit. The margin of appreciation in Strasbourg terms defines the room for manoeuvre states enjoy when designating and implementing their laws and policies. The court identified that in the context of climate change, there is a differentiated margin of appreciation. When it comes to the state's commitment to the need to combat climate change and the setting of the requisite aims and objectives, this calls for a reduced margin. But as to the choice of means, the margin has to remain wide. This margin covers, of course, operational choices and the adoption of policies in order to meet internationally agreed targets and commitments to combat climate change. And this is pure convention orthodoxy, given the very difficult societal and economic questions and choices entailed in decisions relating to how to combat climate change and mitigate its effect. I turn towards my conclusion, as I imagine you're getting a little bit tired of the science and the law, but that is to the question of judicial embrace and rejection of the climate change rulings. In the days following the rulings, the law blogs hummed. In the main, the humming was positive. Newspaper columns were filled with opinion pieces whose stance for and against reflected the political moorings of the paper or the publisher printing them. Lord Sumption, again, in the piece I quoted from the Times, pointed out that climate change is a classic polycentric issue. There's an urgent need for measures to address it, he recognised, but governments have to take a far wider range of factors into account. But the learned judge seemed to be unaware that he had touched on key points highlighted by the court in itself in the Swiss judgment. The relevant paragraphs are clearly identifiable if, after tonight's lecture, you want to read all 625 of them. The court's rulings, crucially, do not contradict his position. They agree with his position. They don't underplay the complexity of the task facing executives and legislatures, and they repeatedly state the primary responsibility for climate action is not located in the courts. As could have been predicted, the rulings have also since felt the warmth of judicial embrace and the chill of judicial resistance. At international level, and I think this is telling, of the 60 European, inter-American and international judges who have ruled on systemic mitigation questions since April 2024, 59 of the 60 have rowed in the same direction on core legal issues. I'm not a cricketer, but that's not bad innings. Courts in countries like Spain, which previously deemed climate change cases inadmissible, have since admitted them for review. The spirit, if not the word, of the Swiss case features in national cases on planning and licensing. I'm thinking of cases from the Northern Ireland Court of Appeal and the Scottish Courts of Sessions. One of the values of the rulings could be described as context and framework creating, with national courts calling on the authorities to take climate protection into consideration in their manner of decision-making and in the weighing of competing interests. Courts in this way act as governance catalysts in climate cases, but they cannot and do not come to the final solution. In 2024, the UK Supreme Court ruled on a challenge to the authorisation of a petrol extraction project at an offshore site. In this case, Finch, it held by a majority, crucially, 3-2, I'll come back to that the planning authority's decision to grant planning permission had been unlawful because the impact assessment had failed to assess the effect on the climate of the combustion of the oil to be produced. There is an open resistance movement. Its form, what it responds to, and the imprecision with which it characterised the jurisprudential object of its criticism, namely the Strasbourg rulings, are, I must admit, fascinating to me. And they led me to pose the question which I posed to you at the outset. I'll take an example, which is the UK, and which, as you know, has a complex relationship with the Convention. It struggled for some time with its European membership. The Brexit dust hadn't settled before calls for convention reform or exit began. And the most recent catalyst has been immigration and asylum malfunction, about which governments in Europe have very legitimate concerns. But the climate change rulings have provided perfect grist for the resistance mill. However, more often than not, I have the impression that the critics contented themselves with reading Lord Sumption in the Times, or proceed on the basis that the Swiss parliamentary reaction to the Swiss judgment, which was angry and emotional, is representative of the general view. Few, if any, seem to have read the rulings, the 3 rulings from Strasbourg, or realised what courts around the world, from Pakistan to Colombia and New Zealand, are doing on the climate front. Or indeed, few seem to realise how modest the Strasbourg Court's judgment is compared, for example, to the judgment of the ICJ or judgments from the Global South. One example illustrates what I think is the subtle opposition or ire which can be aimed at the foreign judges in Strasbourg. In the Finch case, which I just mentioned, the UK had to decide on this planning application. It was divided 3-2, but in that case, crucially, the European Convention of Human Rights played no role at all. Nevertheless, Lord Sales, who I must stress is an absolutely superb judge and who I know was your keynote speaker last year, he wrote for the minority, and he felt the need to reach for the cautionary words of Lord Bingham in response to what he regarded as misconceived responses to the worthy cause of combating climate change. Quoting from Hamlet in relation to the Convention, Lord Bingham had once said, and I quote, "The Convention is concerned with rights and freedoms which are of real importance in a modern democracy governed by the rule of law. It does not, as is sometimes mistakenly thought, offer relief from the heartache and the 1,000 natural shocks that flesh is heir to." I fully agree with Lord Bingham, and many hundreds of the single judgments I had to hand down responded to that problem. But even if a reading of his statement from the Brown case were to justify its use in other cases regarding convention complaints, it is hard to understand its use in a case which had nothing to do with the European Convention. Unless, of course, one sees in the obiter of all obiters, in Lord Sales' opinion, a shot across the bows of the climate-conscious majority in future UK Supreme Court cases in which convention issues might arise. I'll turn to my conclusion, as I have laboured you far too long. And I too will reach for the wisdom of Lord Bingham in my conclusion. In 2006, he was adamant that, and I quote, "The rule of law requires compliance by the state with its obligations in international law." What was so simple then is portrayed as so complex now, with judges and courts criticised for poking their judicial noses where some consider they have no business to be. The sin is even greater, I can assure you, if you are a foreign judge. In extracting and structuring the key takeaways from the 3 Grand Chamber rulings in Strasbourg, my aim has been to demystify them, to clarify them, to emphasize the convention orthodoxy of most of the key components in these rulings in relation to the central role of democratic decision makers, the central role of national courts, the margin of appreciation, the due diligence core of the positive obligations imposed, or the continued prohibition of actio popularis. Where innovation under the living instrument must be conceded, it is in relation to standing, something which your Supreme Court has not shied away from, and recognition of the intergenerational dimension in cases of this nature. Whatever the future, the immediate significance of the Strasbourg climate change rulings cannot be denied. They were the first but will not be the last engagement of a European or international court with one of the greatest challenges of our generation. It's for you, as decision makers, judges, professors, legal scholars, practitioners, students and citizens, to decide where you stand in relation to policy and in relation to the role of courts and the limits thereto. But I repeat again, at a time when the custodians of factual authority are under pressure, if not siege, the Strasbourg rulings showcase the existing climate change science, and as other courts have done previously and subsequently, it has conferred on that science the imprimatur of judicially recognised fact. I return to the beautiful description of the work and person of Judge Cooke by your former Chief Justice, Elias, to which I had access. Judge Cooke was of the view that, and I quote, "There's not much point in accepting judicial office unless one tries to accept the unwelcome or disturbing, but crucially independent responsibilities that go with it." I'm sure the judges here present know today only too well of what he spoke. I know that I do. My warm thanks for this tremendous honour from an Irish jurist who literally crossed oceans and time to be with you. It has been a real pleasure to be introduced to New Zealanders and to New Zealand this week, and it is a place where I discovered real manakitanga. Thank you very much. Guruvmila Mahadev.
So what we're going to do now, very briefly, is to have a couple of to-the-point questions, because I know that there are a lot of opinionated people here who would like to ask questions. But there's a couple of very quick questions. We're happy to have them, but it has been quite a long and fabulous lecture already. So if there's some quick questions to ask. And I know there are students. So Ree.
Kia ora, my name is Ree. It's dawned on me looking across the room. I'm a claimant in a case currently before the Supreme Court challenging oil permits in Taranaki, and I don't purport to imbue any opinions on the justices here and the justices who've already decided on the case. But my question is, what do you think is the currently most untapped potential in climate litigation?
I think you started your question with crucial information, which means that I won't be answering it, precisely because it would put the judges here present in a difficult position. And because I think after 50 minutes, I tried to highlight the key elements that courts face in terms of questions and challenges. And I feel like I've just come out of the rugby scrum on Soldier Field. So if you don't mind, I'm neither going to trespass into pending judicial cases or say more.
Question. That's good. So I promise to be short, particularly as there's no drink afterwards to reward you for having listened to me. So for those of you who don't know me, I'm Jeff McClay. I'm lucky enough to be speaking on behalf of my colleagues to thank our lecturer and to make some observations about the year. But before I do either of those, I just want to acknowledge Bryony. The law school does very little without the university, and I would do very little at all without Bryony's support and help. So I just want to acknowledge that. The university sometimes has faculty sometimes had a bit of a fraught relationship. Looking straight at the Keiths, they've got a long history of relationships between the university and the law school. I just want to acknowledge that the university is our number one supporter, and Bryony is principally responsible for that. I want to then thank Síofra for the journey that she made. I went to Wellington Airport to pick her up. I had no idea really who she was. She had no idea who I was. Within 2 minutes, we had discovered that she had gone to university with my goddaughter's father. So although she's travelled a long way, and then we walked out into the wonderful Dublin weather that was just outside the airport. So I think she felt a little bit at home. She has been what we would say in New Zealand terms, an awesome visitor, awesome with an O, as we spell it here. She's been game in all the events we've thrown at her, and she's done them with aplomb, even though she's just literally come from New York. And she's done an extraordinary job talking to judges, talking to my colleagues, and this wonderful lecture tonight. So I want to acknowledge that. Before I say anything about climate change, I also have to acknowledge something else. For those of you who venture onto Twitter or X, you will be able to find some tweets that I made once about the role of courts in climate change. The down low is, there is none. And one of my students questioned this. So I have to acknowledge that I was on the court skeptic side of things, and I remain a little bit on the court skeptic side of things, not looking at anyone in particular in the room. But listening to our lecturer tonight, I was reminded of why I like doing law, because one of the things about law is that it's kind of remorseless and relentless in the way it focuses on the facts and the cases that people bring before it. And that's one of the things that we have learned watching the climate change litigation over the last 5 years in New Zealand, that it's not quite as foreign to our legal system as we might have thought that it once was. And I just want to acknowledge Rhea, who spoke before, to acknowledge that one of the important parts of this journey for me, although I don't particularly believe that courts have a huge role yet, is the role of our students. One of the greatest moments of my career will always be watching the argument in Smith and Fonterra, when despite putting to one side the Auckland graduate who started the argument in Smith and Fonterra, the substantive legal argument in that case was presented by 3 of my students, all of whom had done torts with me, and an hour of it, Stephen, was my 1996 torts lectures. It was one of the proudest moments of my life, because something that I had never thought would ever be argued was being argued with things that I had taught students, and that they were disagreeing with each other by using the things that I had helped them learn. And that's an awesome experience. I think that one of the things that I learned from listening to judges talk about climate change in their judgments, and I learned tonight, is how much they learn from each other. And this is a controversial time to be learning from other judges in other countries. There are some people that don't like this. There are some very vocal judicial critics, both in New Zealand and in other countries. I fear that Lord Sumption may be one of those people. But that's inevitable for us. In some ways, trying not to learn from other countries would be extremely foolish in a country like Ireland, of not that many million people, which has always learned from overseas to its great benefit. The other thing I want to acknowledge is that this university and its students have done an awesome job, whether one agrees with them or not, and I can stand here because I'm not influencing judges, is just to say that one of the proudest things I say in many forums, whether they win or lose, is that my students took our government to court. And I think that's awesome, and I salute you, and I salute William and the others who are responsible for that, and also their lawyers, some of whom are in this room, not because they should necessarily win, but because that's exactly what we train our students to do at this law school. The last thing I want to do, if I could, is just acknowledge my colleagues who are in this room and who aren't in this room, people ask me all the time, what's it like this last year? And I reply, and people misunderstand me, the karakia that was done in the farewell to John's predecessor, Peter Bosher, Te Atiawa did this fantastic karakia, which was described in the following ways. So the waka goes up and the waka goes down, which is how I pretty much spend my days, going up and down. But as I understand, the point of the karakia was that you actually get to where you're going to if you keep on going. And that's what we're doing at the moment. Now, in universities, it's a bit bizarre to take the waka analogy too far, because I really don't. I think it's a bit hopeful to think that all academics are going to row in the same waka together all of the time. And Bryony can give you some good examples, I'm sure. But I sort of take inspiration from the fleet approach that we've so benefited from in our history, that people rowing different waka can get to a wonderful place together. And I hope that's the way my colleagues feel. It's a hard job, sometimes a difficult job, but we get great hope from seeing the sorts of audiences we have tonight. If I can just come back to the topic of tonight's lecture, one of my jobs is to try and convince students at high schools in New Zealand to come to our law school. And so I use Smith and Fonterra, not because I necessarily think it's right, but because David Bullock, who was one of the Vic graduates who argued the case, who I think did a lot of the intellectual hard work to try and figure out how you made this analogy from traditional tort cases in the 19th century to climate change, a problem that was unimaginable in its scope at the time. What I tell these high schoolers, why come to Vic? And I say because we are very proud of people that come, learn from us, and then prove us wrong. And that's what I think our law school stands for. That's why I'm so proud to be at this lecture and the tradition of Robin Cooke, and why I'm so proud to know so many of you. And I'm so proud of our students, many of whom are actually here. So thank you for the wonderful lecture. Thank you all for coming. Thank you for your support during the year. But most of all, thank you to Chief Justice.